Hello again, this has been Hitchcock Cross talking to you with your computer's updating for 2.5 hours, so you're reduced to the iPhone and you got a strange thing routine. How's that going for you? All right, so what do we got today? We have a couple of letters from a department of the state of Wisconsin with good old Tony Evers' name right across there. And we're going to go to our elements for a 1983 claim. The big question here is, can an attorney violate your client's chill your client's First Amendment rights with a letter? Okay, so remember, what are our elements? Number one, you have to have a person acting under the color of state law. Number two, you have to have depriving somebody of a federal law or constitutional right. And then you have to have some act in furtherance of that, and then damages. All right, so let us look. And, we always sort of wonder, what is a state actor? And, was it complicated? And we went through the Ku Klux Klan test and everything. But if somebody's got the letterhead and it says state of Wisconsin, and then it's got a department there, and it says Governor Tony Evers, and it's signed by, the Office of Legal Counsel for that department, you kind of think that person is going to be acting under color of law. So that's I think our first check right there on that analysis right there. The next thing that we've got to think about is, are they going after you, depriving you of a federal right or law, okay? So let's look into this letter here. We got a couple of them. May 20th, May 21st, I think, and then May 23rd, okay? So we got these in pretty rapid fire succession here. And that is, we'll ask this as a hypothetical. What if the government sends you a letter and it's talking about let's put it like this, you're uploading YouTube content pertaining to this case, including content that they allege defames a government employee, high-ranking government employee, apparently. Your treatment of this high-ranking government employee is regrettable. The high-ranking government employee is hard-working, innocent public servant. Huh? As I have previously communicated to you, I really don't want to see another attorney dig themselves any deeper than they are already. Okay, and she puts a little footnote there that says, for that matter, your YouTube contents also maligns current and former public servants. Okay. Now, okay, we brought up YouTube. That makes sense here. The client's discussing the case on YouTube. Got that. And then we get into, you need to sign an agreement that says, what if it just says you need to sign an agreement that says you won't put any of the stuff that we get you on YouTube? Just what if they say that, okay? What if they said that? And what if they said that we don't think you should be allowed to depose any former secretaries of their department, or, current secretary either? What if they told you that, okay? And here, let's just think about, what if they had said this, invited you to dismiss the claim, just like Judge Gelhardt from the ERT did. Let's just think about this. As an alternative to moving forward with the discovery process, a perfectly reasonable step forward is to simply dismiss this case. The ALJ's order dismissing the probable cause appeal is significantly communicative. So you should have learned your lesson, I guess. I believe that something along those lines is going to be the net result of the merits hearing as well. Oh, okay. All right, that's the totality of those comments that I could share with you on that one. And let's see what else they might have. Let's see if the next day they sent you another letter with Governor Tony Evers right there and the seal of the state of Wisconsin right there. And it says, I regret that I haven't received a response from you. I wonder if this person got an email immediately back saying that I was undisposed. I don't know. That you could see. I note that less than an hour ago, you uploaded new content to your YouTube channel in which you discussed First Amendment and other Section 1983 claims in a federal case. Oh, I wonder if they went through those, the elements. If that's the one they're talking about, where we go through the elements of a First Amendment rights. I wonder if they did. Find out. I observed that in the past 6 days, you have uploaded 6 new videos. It would seem that you have time to create content for your YouTube viewers. You should probably finally time to respond to outstanding discovery in this case. What if they said that? I don't know. Let's see. Your law license is on the line. What if they told you that? Who knows? And what if, 2 days after that, they sent you another correspondence with Governor Tony Evers' name on there and the seal of the state of Wisconsin. What they sent you that. And it, again, I wonder if it mentions YouTube at all. Well, this one mentions on the 3rd paragraph, I note that you uploaded content to your YouTube, as you again did this morning. I previously editorialized, if you have time to create YouTube content, you have time to respond to my discovery. Could be a perfectly fair statement. Who knows? Okay. Oh, but I wonder if there's some kind of implied threat that would be after that. So what if you got that from one member to a bar of the other? I am very concerned that a fellow member of the bar is being so cavalier with his law license. Oh, okay. What if the person suggested that if you have a problem, if the problem involves substance abuse or mental health, that you should seek counseling? And then they included with this document, what if they sent a demand for you to sign a stipulation and order providing that would mean an agreement that you wouldn't put any documents that they provided to you in the case on YouTube? What if they did that? What would you think that would be chilling your free speech, your client's free speech? You tell me. I don't know. It's hard to tell. Let's go over them again, though. I don't know that they're that hard to remember, but it is always nice to do that. You've got somebody acting under the color of state law. I mean, I got to check that with the seal. You've got an action chilling your free speech rights here to go on YouTube to talk about this case. Also, to your due process rights to file the case to begin with. Equal protection. You also got those rights as well. All of those I can name are constitutional rights here. Those would seem to fall in there. The equal protection would be, well, why are they treating everybody like this? Or just the people who go on YouTube? Or just the people who try to, exercise their rights against high-ranking government employees, for example? Are those people being treated differently than other people? That might be equal protection. We went over that last time. Obviously, we might say First Amendment, right? People have a right to go on YouTube and discuss their cases if they want. If they want to have their attorney do that, they can absolutely do that. It's America. You got a right to talk about things unless there's some rule that says you can't, which there may possibly be, but I haven't seen anybody cite that here. So that's, I would say that's the next thing. And then what about exercise of your due process rights here. And I think the statement that I think was exceptionally chilling of all the rights and the standards, obviously there's different standards for different rights. The standard for example, chilling First Amendment speech is pretty low. The standard for equal protection, I'd say, is more so. And due process, I think that we're talking here about the ability to actually file a complaint. And I think there's clearly is some allusion to, and these different statements can be taken different ways here, but that really is the question, is how would you interpret these kind of statements if they existed? How would you interpret such statements from a government actor telling you to dismiss this case here? And I guess I note here the difference between the judge telling you to dismiss the case, and they might have qualified immunity here, and this person here telling you to dismiss the case and shut up. And I think that is important to keep in mind here. It's the and shut up part. Do you think that people should have the right to exercise their First Amendment rights even when the government actors are involved? Do you think that the government should be able to, whether it's, for example, the Department of Workforce Development and the administrative law judges there, do you think they should be able to tell you to shut up? What about, do you think that the attorneys acting on behalf of the state of Wisconsin should be able to tell you to shut up when you go on YouTube? And now, what if there was a steady stream of correspondence from you to them saying, we need to talk about this discovery, we want to get it to you, but we've got to talk? And what if, they were allowed to go on vacation, but you weren't? What if you went on vacation, they then sent you on the 20th, 21st, 23rd, just like that, for example. What if they sent you that information there? How would you feel about that? So, I guess that really is your question here, is are we at a 1983 claim? You tell me. All right, stick with us. We'll keep you informed.